Yeah, swag.
Welcome to Attorneys and Swag, the show you come to watch attorneys talk about the law because it matters to you, because it does. This is Attorneys and Swag. I'm Eugene Toussaint, and I'm here with my co-host.
Everett Hopkins, as always, born and raised in Jamaica, Queens.
Judbril Oladiran, born in Jamaica, Queens.
I'm the guest, Felipe Garcia, born and raised in Bogota, Colombia.
Bogota, Colombia.
That's right.
Shout out.
You need some Spanish flavor here. That's why.
International.
All right, I'm here.
This is Attorneys and Swag, and on this episode, we're going over trials and how you should not want to be in one. Right? So that's going to be the topic for today. We're going to go over everything, how we decide, how we help our clients decide if the trial is the right thing to do, and why, if it isn't, how we make that determination. And helping us have that conversation, as he said before, is our special guest, Felipe Garcia. Felipe, before we get into the topic, give him a little background into your experiences.
All right. Well, just a little bit about me. Born and raised in Bogota, Colombia. Lived there till I was 13 years old. Moved to the United States to Clearwater, Florida. 727, my heart. Grew up there. Went to undergrad at Florida State University in Tallahassee. Went to law school at GW Law. And now I'm a public defender here in Queens, New York. By no means I'm the expert in trials, but I've done a few of them, so I can talk about them. It's been a good run, and that's who I am.
So I'm introducing a new segment because I kind of want to lay down the conversation and catch you guys up to how I personally feel about trials and how they are a means of a last resort. I don't know if I'm saying that right, but they should be the thing that if a criminal case is a highway and you can get off earlier and get off safer, maybe you shouldn't drive to the end. That's my opinion about trials. And to lay that out, I'm going to explain that further. I'm introducing a new segment, and this is shit that happens. And this is a fake story. Any of my old clients, if you feel like your experiences fit in this mode, I am not talking about you. Don't get it twisted. Don't get it twisted. This is more of a fake story I made up that kind of captures the collective consciousness of all my experiences. Or hypothetical. And this is not a Gene and Jay story.
That's a hypothetical too.
That's hypothetical.
I don't know why you brought that up, but continue.
Just saying. Degrees of separation.
Hypothetical.
Some
taken
things
from
are
real
faker
life.
than others. So
Personal experience.
basically,
Eugene Toussaint.
all right. So I'm gonna tell this story, right? So it's 1 a.m., right? You're a dude. You're in your kitchen. You live with your girl. She's your wifey, number one girl. You live with her. It's 1 a.m. You're in the kitchen, and you're making a sandwich, right? Because you're hungry. You're kind of tired. You're really tired, actually. But you're hungry, so you gotta eat. Have a nice little, make yourself a sandwich before you eat, right? But this is the Bronx, where all these stories happen at.
Of course.
But of course.
Shit that happens.
And
So shit about to get bad, real quick.
So yes. But because of your previous experiences, even if you're in your own house making a sandwich at 1 a.m., you still got your fucking peripheral working. No matter what happens, keep that shit on.
Because you're in the Bronx.
Because you're in the Bronx. And outside your peripheral, you see a person with a bat. And that person is coming towards you. And you're kind of sitting there going, well, only my girl's in the crib. That doesn't make any sense. Oh shit, that person's swinging. This person swings a bat at your head. Lucky for you, you had your peripheral on, you ducked. She missed.
Your wife.
In this scenario,
I was going to say,
Wife.
I mean,
Right there?
one plus one is
right
two.
there,
She's the only one in the house.
Yeah.
so she swings, she misses. You're like, whoa. She's trying to knock my fucking top off. That was a kill stroke. What the fuck did I do?
Yeah, what did you do?
Oh shit, what did I do?
Yeah, that's right. Everybody's
What
like,
did
what do
I
you do?
Right. What did I do? Oh fuck, I know what I did.
She knows too.
If she's murder mad, she got into the secret app that holds my secret text.
Is this a client story?
This is a hypothetical.
Brought to you by AP4.
Brought to you by AP4, exactly. This is the AP4 kid.
Yo, yeah.
Right?
DV,
So
DV, that's
you're
what
seeing, you know what it's him for. You're also thinking, how does she know how to work the secret app? What the fucking secret tech she got? Well, she's swinging again. So no time to think for that. Misses again. Breaks the fucking microwave. So now you're sitting there and you're realizing, like, fuck, I need to get this bat out of her hand because I'm 185 and she's 115. And she doesn't play baseball, but that's a fucking metal bat. And if she hits me, it's gonna hurt. Yeah. So she swings again, she misses, you get the bats out, you rip it from her hands, you throw it. She's still coming for you. She's laying some context to what's happening. Yeah, she found the Texas.
Oh, yeah.
Right?
She 0 for 3 though.
She's coming.
Yeah,
she's coming. You're starting to worry about there's knives in this kitchen. So you're just trying to protect yourself. You're not trying to hurt her. You kind of know that you almost to a certain extent deserve it. You don't deserve her to murder you. You're really happy you didn't fall asleep. Because this shit would have worked out a lot differently if you were sleeping.
You would have known. You've been dead.
You'd be dead, yes. But you're trying to protect yourself, right? And in your protecting, you're giving her what we could describe as defensive wounds, right? You are shoving her, you are pushing her away from you. And in that process, in the process of your self-defense, fight or flight, you're injuring her, but you're not trying to. Because what you're trying to do is get the fuck out that house. You do get the fuck out that house, right? You're out the house, you're stressed, she just tried to kill you. You know she just tried to kill you, but she's your wifey. And you know at the end of the day, you basically fucked her head up, and she snapped, but she shouldn't do, what's attempted murder? Felipe, you to guess? What's attempted murder?
What? 5 to 25. I mean, it's a B.
It's a B. It's a
felony.
B what?
Yeah.
B violent, right?
Be violent, yeah.
So you call the cops. You're gonna put a person you love into a lot of shit, right? Assuming people who cheat on their girls still love them, right? You know what I'm trying to say, right?
I mean,
Stay on track, bro.
I'm trying to.
you
know what?
You know what?
You don't
That's
wanna
a
do
name
that.
misdemeanor.
Don't worry about it.
That's a criminal
So
mischief
you don't
right
want to
now.
do that. What you want to do is just relax. You want to let the situation calm down. You don't want to go back into that house because at the end of the day, she just did try to just kill you, and you don't want to kill her, right? And you're a teacher. You don't have no criminal record. You're not trying to make your life any worse. So you leave, but it's 1 a.m. Where do you go? You go to your side chick's house because she's the only one that's going to answer the phone.
God, bro.
Now, while you're doing that,
There's a lot of detail in
Yeah.
this.
don't worry.
It's hypothetical, right?
It's a hypothetical.
Are you sure it's a hypothetical?
I'm sure it's a hypothetical. I don't do none of this shit.
Myra would never find us.
So, why did you do that? Because you're trying to rest. You're trying to fucking take the volume down because this shit is crazy. You know what she's doing? She don't trust you.
She called the cops.
She's calling the
All the
cops.
fucking cops.
She's calling the cops, right?
In the Bronx.
And why did she call the cops? She called the
Yo,
cops.
she's-
She called the cops to protect herself. But she
Of course,
overdid
'cause
it.
you think she's doing
She
it.
overdid it, right? Because she made it sound like you came at her with a bat. And that microwave is broken because you tried to hit her with a bat. And she's a fucking ninja and you didn't hit her somehow. Right? And all these wounds, that's because you tried to kill her. So while you are trying to rest, like just fucking take the temperature down, there's detectives out there looking for you. And they're about to hit you with the B. B violent felony. 5 to 25. Right? Now, my question to you is, and the point of this story, is that this is an innocent man. Innocent man who, he did morally fucked up shit.
Innocent of attempted murder.
Attempted murder, yes.
Yeah.
Do you want to take that case to trial? Felipe?
I mean, I think there's a lot of shit we don't know as to the story itself. I think that one of the things that you got to think about actually before even when you're considering trial or not is the exposure. Like you say, 5 to 25. Right. If they give you an offer that is way better than 5 to 25. I mean, and mind you, I don't know all the things that went through, during this investigation. Maybe the cop did something wrong. Maybe she said something one day, she said something a different way. Those are all stuff you gotta, you can fight in trial, but you always gotta look at the offer.
I guess the point of this is that the point I'm trying to make is that innocence doesn't protect you from shit. Because innocent people can be convicted at trials.
You're right.
Yeah, 100%.
You're right. Innocent people take pleas in our criminal justice system
All the time.
the time.
And why is that?
All the time, because you're right, because they find themselves in a fucking issue like that, like, facing a lot of time. They give them a plea. Even, let's say you plead to disorderly conduct with some anger management. You're still pleading guilty to something you didn't do.
Right.
And sometimes you gotta eat it and do it because of the exposure, because the magnitude of losing a case is so high.
My experience with it is that people will take a plea simply because they can't afford to keep coming to court. Like, these cases don't happen very quickly. Like, a lot of times, for a case to go to trial, it takes at least a year. And so during that year, you're coming back to court maybe every 1 to 2 months. You're missing work, you're missing time with kids and, traveling and stuff like that. And if there's immigration issues, you can't leave the country. So a lot of things play into why innocent people might want to take a plea. Because after a while, after a year and a half, my guy might just be like, listen, I didn't do this, but what are they offering me again? All right, I won't get a criminal record. It's a violation. All right, I'll just take that so I can just keep going. Now, he just pled guilty to something, but, at the end of the day, he might have had a good case and could have won that trial. So the way the system is built, it cannot sustain itself.
Mm-hmm.
And just for
If
y'all,
everyone innocent wanted to go to trial.
I concur. Just for y'all to know, sometimes like Eugene characterized it as attempted murder. Sometimes the police think it's like attempted murder, and they arrest you on that felony.
Right.
But when it comes before the district attorney's office, they look at it and they're like, okay, this is not attempted murder based on injuries, based on allegations, and then they might charge it as a misdemeanor. So just so you know, sometimes you might think you're in hot water and you're not, and sometimes you don't know the thing that you did. They are felonies, and it's crazy.
And it happens all the time. Right?
Yeah.
Like,
Arrest
arrest
charges
charges are
is always
completely
high.
different than what
Yeah.
you get in the complaint report.
Yeah, I just sprinkle a little exaggeration on all my stories.
Yeah.
I mean, look, but you know what? But you know what? Like, that story, it in essence,
It could
could
happen.
happen because
That's exactly how it
because
could happen.
I'm sure it does
what determines the charge, right?
Right.
The DA determines the
The
charge.
DA
Right.
determines.
So let's say in that story you get a DA that it's like, oh no, like, this is definitely not attempted murder. Okay, it's a misdemeanor, boom. But what if you get another one that says, okay, this is worth that?
Yeah.
Then
Well,
you're
I
a
mean,
completely different animal.
If you
It's a
have
completely
a
different case.
prosecutor who thinks you missed at a bat swing to someone's head, they can if they think that's what happened, they can call that whatever the fuck they want.
But that's what I mean. I mean, it
Attempted
just
assault
depends on the
one,
DA.
attempted murder.
And
like
you know
something.
what? The one thing, and I know this trial episode is good, and what Everett said is excellent, because when I started working, there were not enough trial parts to go around, and people's first trials are felony trials.
Oh.
Right now, what we see is different. But my first trial was a felony trial. I didn't know how to try a case.
I didn't know that.
Yeah.
Damn.
Did you
My
tell your
first trial
client
was a
that?
felony trial.
Did you tell your client this is
You
your first
can't
trial?
tell you can't tell your client. I mean, my client actually never asked me. My client actually never asked me.
You tell your clients that?
My client actually never asked me if it was my first trial or not.
Oh yeah.
Never.
But you have a supervisor.
I
and
had
stuff,
my supervisor
Yeah,
next.
you got
I had the person who taught me next to me.
Yeah.
So
And I went in and I did my thing. But that goes to show you that if you want to be a trial attorney, it's not going to be like a little staircase. You do this and you do that. No, like you might be thrown out there, do your thing, and you gotta be ready for that.
So the point of that story was to simply say, before we even get to the trial, how do we make that decision? What do you think are the important factors you're considering with your client, right? Like a big word you use is exposure, right?
Yeah,
Exposure is a huge word. One of the things I consider is, do you have a criminal record? If you don't have a criminal record, right, and they're offering you a pathway to maintain that status, regardless if it's fucking 52-week sex program that you shouldn't do because you didn't rape anybody or whatever it is, right? Whatever the case is, but there's a way for you to guarantee that when you get off this highway of your criminal case, you'll walk away with no criminal record. I feel like that's always very hard to turn down, regardless of regardless of your innocence or not, because your innocence might not be equate to the strength of the case, but almost even regardless of the strength of the case, because a bird in the hand is always better than whatever's in that fucking bush.
You're right.
I think that for me, it's like no case is a slam dunk. There's no case that is just a slam dunk, 100% win at trial, right? Anything can happen.
I don't know. Ask Eugene. Are there slam dunk cases?
My slam dunk cases get dismissed.
So therefore,
but that's what I was going
so
to say.
therefore,
Though.
okay,
Well,
then
I
break-
think what he's
break
saying is
your-
that
I know.
Why-
You made the point though.
why isn't there slam dunk trial cases?
Because those cases should not go to trial,
Yeah.
right? Because and it goes both ways. If a prosecutor has a real good case, my guy on video, statements made, admissions, 50 witnesses lined up, why am I going to trial, right? Why? When I can take something that will be less than what he would get at trial, I shouldn't go to trial in that case. Vice versa, where, and this is just my opinion, if I have a really good case, like what's the best case for a defense attorney, right? My client is on video
That's-
50 miles west
Oh,
of
that's
where
not-
the crime
oh,
happened,
I mean,
right?
that's, yeah.
Dismiss.
Right, that's the
Why?
best.
They're not
that's
going-
the
they're
best,
not going
right?
to trial on that.
So what prosecutor would go to trial in that case? I have a video of my guy not even at the scene.
The fear is that if all things being equal or perfect, an innocent man shouldn't be convicted. But there are elements outside of our control, and one of those elements outside of our control is the misunderstanding of the law. And what you're
Yes.
saying is that anyone who's being charged with a crime has no requirement
Right.
to testify.
We have no requirement to do anything.
Anything.
No, but I think that
So
before we even get there, what Eugene was talking about, why we take, why pleas are so, why we take so
Prevalent.
many pleas, and why we don't go to trial. I think was one thing that you guys haven't touched on, which is, you're undocumented. It's a huge thing.
I know exactly what you're saying.
So-
I avoided a trial on the eve of trial. That it was a DACA
DACA.
client,
Yeah.
right?
Yeah.
Deferred act. What is it? Deferred arrival. What? I don't know what it is. What's the
There's no
DAC?
DACA.
Huh? It's deferred
Action childhood arrival.
arrivals.
Deferred action
okay.
childhood arrival.
Yes,
Yeah.
right. So this guy had DACA status, and because of that, he couldn't be deported.
It's a DWI?
Huh?
Was
It's
it a DWI? I know, yeah, it was a
DWI, right?
Because you
So
lose
it's-
your shit if you had an
And like they're offering an impaired,
Yeah.
right? An impaired, so the audience understands, is you get charged with a misdemeanor because you blew up above a .08.
or
tip-
maybe without it.
Yeah,
Oh, yeah,
they're
so
typically gonna
You get charged with a misdemeanor DWI.
Yes, and they're typically gonna offer you, depending on what jurisdiction you're in, a traffic infraction, driving under the influence.
Driving while ability impaired.
That one.
Yeah. That's what it is. Driving
Right.
while ability impaired. It's an infraction though.
It's a traffic infraction. It's like a speeding ticket.
Right.
For us, normal citizens, right?
Yeah.
But someone with DACA status, that is a reason to invoke your DACA status.
Your status.
The status that you have that's protecting you, that's keeping it so that you can have a social security number or have whatever they get and be able to work, right? Because that's the whole point of the status, is that it gives you a certain level of protections that you can then use to work and do go to school, work, get
Yeah.
FAFSA, do all these things. Taking that traffic infraction, which for a citizen is a good offer if you actually was caught in the mix, will evoke your status. So it kind of became like, do you want to lose your status on a misdemeanor, or do you want to lose your status on a violation? At least if you lose your status on a violation, you are in a slightly better position.
So
We had to push to the end, and like this is like probably the most effect I think I ever had on a client's life, which is on the eve of trial, the third time through, I re-argued this motion several times, and finally the judge understood what I was saying, and they granted a dismissal right before we took the
Yeah.
plea. It was like we were gonna take the plea, and they granted it.
So I think that you're talking, what you're saying, it makes sense because you evaluate a case differently based on who your client is, and I think that's what we do on an everyday basis. And for a client who maybe makes sense to take an A misdemeanor and a city bullet, as you said, another one may not make sense. You maybe need 30 days because of immigration consequences. So that's how you evaluate a case in terms of even going to trial differently, and my goals are very clear, and I'll share them with you. When I have an undocumented client, the first thing that I think about is, I don't want you to get deported. If my client, let's say, it was born here in the United States, a citizen, the first thing that I think about is like, okay, guess what? Let's keep you out of jail. Let's keep you out of jail. First thing that I tell them is, let's keep you out of jail. Maybe you have to eat a misdemeanor, but I want to keep you out of jail. It's misdemeanor criminal record. Obviously you don't want him to have a criminal record, but if you got a criminal record but get a CD, something to think about. So it's like, you have to think about based on the case. And
I always put in the framework of risk-reward analysis. I literally say, what are you risking compared to what is your reward is, right?
Yeah.
When my clients are offered a violation or a pathway to a violation, I then start saying, well, at the end of the day, you're gonna have a violation. And this is a bird in the hand. This is a off ramp. This is exit 30. You're gonna get off. You know where you're going home to, right? Now, we don't have to take that off ramp. It's always your decision. We're gonna do whatever you want. Like, I'm just giving you advice. Cause this shit ain't happening to me. It's happening to you. And I'm standing next to you and helping you happen to you, right? Like, and like, if you don't want to get off on that exit, that's fine, right? But then what does that mean? What are the likelihoods of what's gonna be the next opportunity to end this shit?
Yeah.
And how likely are we gonna get to the place we want to be as compared to the place we don't want to be? Because if you take this exit now, you know how to get home and you know what it's hitting for. You keep going, it's a pathway of uncertainty, right?
So what you mean is like, okay, in your analogy, okay, you have a chance to get out of this exit and it's in your hands. If you go without the highway and you live in the jury's hand, maybe you will not get out this highway.
Exactly.
Maybe you'll reach the end of the highway, which is not where you want to go.
Yeah.
You know, the jury has a chance to get you out of the highway by saying no guilty. But if you take the plea, in which you are the main driver, you can get out the exit if you do what you're supposed to do.
Yeah.
All right, so we briefly touched on immigration. So I know this will be like a touchy subject for people in general, the public. And so taking a plea or not taking a plea is also dependent on the judge you're before. For political reasons, a judge will not allow you to take a certain plea because you're doing it for immigration purposes, and other judges don't mind. And it's actually like a big political thing that's going on in the courts. So even like going to trial, you're going to trial because maybe the DA's office is not offering you a certain plea that will not make you deportable, and that's why you're going to trial.
Which is, people don't think that really happens. Like, that's like, you can just end up doing a trial simply because a judge, you know, particularly doesn't like your client for whatever reason, and now you got to do this trial on a case that maybe necessarily shouldn't go to trial. Where like I've shown up to court several times where we've had a deal, prosecutors on board. If the guy's doing like a program or something, the program coordinator's on board. They have a bed or a spot ready for him in the program. My client wants the plea. I want the plea. It's best for him. And the judge is like, nah, this is crazy. You know, this is crazy. Nah, I'm not taking this plea. And you know, and there's no reason. They don't put any reason on the record. They don't have to. And just like how the judge may be the arbitrary one making that decision, a lot of cases with their outcome just depends on what jury you have. Like juries, I think trials to a certain extent can be won in jury selection, the way you pick a jury and what jurors you have. So if you have a good jury where, you know, they're making a lot of eye contact with you and you're saying things and they're nodding and they understand, you're able to relate to that jury, that's
I think that's 85%.
Yeah,
where you win the trial.
It's a lot.
85%.
85% where you win the trial is jury selection.
So I think, to a certain extent, I think part of your due diligence as an attorney, right, is if you think that your client is making the wrong decisions, that's undone, right? But you better be at the end of your job. Like, you better have done your due diligence and made your best attempt at convincing them to do what you perceive. You went to law school, you have your experience, you talked to your supervisor, you've done everything you did, and you're saying, like, yo, this is what the advice is.
Well, you gotta
right?
inform them, right?
You
Like,
have to
that's what
inform
it comes
them.
down to. I mean,
But you're informing.
It's not your life.
It doesn't end at saying it out loud. It ends at, like, if I say something out loud, in normal life, whether it lands or doesn't land isn't my fucking problem. As a fucking attorney, I have a fiduciary duty to not just say it to you, but to make sure it's understood, and then you make your fucking decision.
I had a guy with like 60 convictions. They offer him an ACD in an AP4 DV case, you know, and I was just like, bro, you gotta, you know, it's a good case, but it's gonna be a bench trial. You know, the judge is gonna determine this. You have all this stuff. The judge is gonna look at your rap. They're gonna know.
Yeah,
and that dude ended up getting convicted. It was a bench trial, but then he got reversed. So I guess he was trying. I guess the dude was, and I told him, I was like, "Yeah, you have a good case, but he's gonna go to a judge, and we didn't know."
Come on, so you had a guilty for as many months it took to get acquitted, to get the fucking reversal.
Yeah,
that's hilarious.
It was funny because the DA was. I don't think the DA thought that he was gonna win the case based on the evidence. So when she said, when she said guilty, he didn't really know what to do, and then he was like, "Oh crap, man! Like I'll give him a CD." I was like, "This dude was like 60 convictions
For sentence.
Yeah, for sentence, for conditional discharge." I was like, "Damn." And he was right
Hey,
because
no
she
jail time.
look, it got reversed, and but that's the thing. Like sometimes clients are right.
Well, I
Like,
have,
contact with the system.
I have one client. He was charged with criminal possession of a controlled substance in the 7th degree, and he was offered an ACD. And the reason why he didn't take it is because he said it wasn't crack. So
That's
I
a good
was
reason.
Was
Test
it?
it.
Was
Test
it?
the crack.
Test that
It
shit?
wasn't crack. It wasn't. So we didn't, and they dismissed it. So
Wow.
there's
But-
other
oh,
reasons. There's other reasons why.
But see, that's a.
Yo, but that's
We're not gonna go over it. That's
Yo,
a,
yo, yo, yo.
That's a
That
Kaylin
almost
case,
never
right? It's
happens.
Kaylin, right?
Look, let's just say this. Let's just say this. That shit you charge with felony, you better forget about it. Like you're not gonna get an outright dismissal just like that. I mean,
that's-
if you're
yeah, that's
charged
true.
with a fucking felony, you're gonna be there for a little while.
Yo,
This ain't on the next court that you're gonna get that shit dismissed. Forget about it.
I mean, listen,
Forget about it.
I've
Like,
had a
that's-
couple dismissed, right? I had a gun
How long
case.
did it take?
Oh, it took a year.
That's
At
what I
least a year.
mean.
And then, without it even being
Yeah,
indicted.
that's
Like,
what
we
I
kept
mean.
waiting. Like, we were waiting for them to test the DNA on the gun. And they actually did it, and they found out my guy's DNA was not on the gun, and they dismissed it, So
And
I
it
think that's the way
depends, though. It
cases...
depends on the case because even
It
if your
does. It
DNA
depends
is
on
not on
the
the
DA.
gun,
Yeah.
they can still charge it.
Yeah,
Yeah.
Depending on where you were.
Yeah, they
All
were.
right.
the cop will say that he saw you with the gun, so the cop's
Yeah.
observation.
Or
is good
what
enough.
about a house?
Oh,
in
yeah,
a
yeah.
car.
Oh yeah. Okay, now we're going. Okay.
Yeah, well, no, but that's what I'm.
I don't know
mean.
what happened in
no,
your
no,
case.
no. It's not even my case. No, I'm just saying, like, you just never know.
So I think we've gotten there. Before we jump into the actual nuts and bolts of a trial, do you mind just laying it out from beginning to end?
What, the trial?
The trial.
So you get there and you're like, why the fuck did I go to trial? No.
You're not
So
excited?
you get like all your blood
butterflies.
taken, all your blood. You're like, you get in there and you start sweating bullets. First thing you get sent out. See the preliminaries. So you do your Sandoval and your Molyneux.
What are those?
Anything else? So your Sandoval is your past crimes that can be used against you.
Okay.
If you
Usually,
testify.
yeah, justify, yeah, and you said we'll get to them later, but what happens is usually you get to a Sandoval
face.
compromise, and we'll talk about later. Molyneux is the crimes, past crimes that you've been charged with, that can be brought under certain things. I call them mimic. There's certain things that you can bring them on, and then after the preliminaries, then usually if it's a jury trial, it's the difference between a jury trial and bench trial. You start doing what is called voir dire. That is called jury selection. Judges say this all the time, and I agree with this. It's actually jury deselection. You deselect the jurors that you don't like. Then you do what is called an opening
We love
statement.
you all, juries.
Yeah, we
Yeah,
do.
we do love you.
We love you all, but some of you just are not qualified. and then you do
For
what
my
is called,
jury.
yeah.
Yeah, for my case.
My case.
You're not good
No,
for
you're
my
Go
case.
for another case.
You're a
You
great-
might be-
Yeah, for
you go
civil,
your
for
jury
civil.
case.
So what you do, you go
great
through
guy.
opening statements. Opening statements, the defense doesn't have to do one. Actually, I like to.
Okay,
do one,
defense doesn't have to do anything.
Exactly, defense doesn't do anything. We'll get to that later. And then you go through the prosecutor's witnesses. They can call whoever they want. I always say that the prosecutor's case is, they're the chef. They actually cook their meal. They put whatever ingredients they want. They want to do whatever they want with it. At the end of the day, it's their meal. If it tastes like shit, throw that case out. You do, after the end of the prosecutor's case, you do what is called a trial order dismissal. And then it's up to the defense to put on their case. They can call witnesses. This is the time where if you have a client who wants to testify, you have to talk to them, and you depending on your defense, self-defense, you might want,
That's all
might
good.
want to attend the defense.
Self-defense.
Based on that, the client may have to testify, may not. You put the client on, then after that you have to do a trial order dismissal. You have to do these two things because they're important for appeal. And then you'll do the summation, which I think, I said 85% is jury selection. I think I have to say that 15% is how you hammer it home. You have to have a strong ending in order for the jury to come back. But before that, you speak to the judge about the instructions, what you want, the instructions of the law that you want to be conveyed to the jury. And after that, the jury goes to deliberate.
And it's just a waiting
And
time.
there's a waiting game, and the jury can come back with notes telling the stenographer to please read the minutes of this witness, or can you instruct me on this and that. But from the moment you sum up, for the moment that the verdict comes, it's it's a waiting game, and it's a terrible waiting game. I hate it. It's the worst part of the trial.
You're literally on call.
Just so I know, what's your favorite part of a trial? I know you said you might not like going to trial, but what's your favorite part, if you could say?
Oof, that's hard because I love jury selection because I have my little, sneaky tactics that I like. Like it's just in a way, it's just like you have to connect with the jury somehow. That's how you win the case.
So preliminaries come before jury selection,
Yeah.
right? But since you're Breal, let's start at jury selection. That is your favorite part, so let's start there.
I love jury selection because that's the time that you can actually connect. And that is the only time during the trial. Yeah, exactly. Like Ev says, like, is the time that you can actually look at them. Like, actually look at them, ask them a question,
Okay.
and then reply to you.
Okay.
You can actually build a rapport with the jury. This is like boom, boom. Like you giving, you're getting, and that's I think that's my favorite part. It's the scariest part, actually.
Okay.
Yeah, it
My
is.
opinion.
I actually I think so. When it comes to before we jump really into it, explain jury selection as to someone who's never even heard of the concept.
It changes from state to state.
Okay.
Some states actually have a questionnaire where the judge is the one that asks questions of the jury, and as an attorney, you can't really ask him any questions.
Okay.
So this is in New York. In New York, they have a little list. Some judges actually give the jurors a list, and they fill them out, and then you get them to the attorney. Now they here in New York, they just ask questions. So it's like, where are you born? Where do you live? And obviously, we all know, people say Astoria. As a defense attorney, you're like, okay, I gotta put, people say Howard Beach. As a defense attorney, it's like, I'm nothing bad about Howard Beach. It's just, for the defense side, it's just not fucking good. That's what it is what it is.
Depends on the case.
Depends on the case.
case.
Everything depends on the case.
Depends on the
Mostly,
case.
don't fucking pick them. It's
Like,
like,
you live here too, but like,
Yeah.
it's based on stereotypes. We're looking at you
I was gonna get there.
as jurors, and we're just looking at you and trying to come up with assumptions as to what you might be thinking. Like,
I don't think
whether you're
that.
conservative.
You don't think
whether
that.
No,
You're
mine,
Well,
is,
liberal-
mine is based on whatever answers you give me. But continue.
Oh yeah. Really? Oh, you're such a nice person.
Yo, he didn't say it. This is civil cases. All right. No, but I get.
Nah, but like you're because now during jury, we're judging you, and yeah, we're using the questions
It's
to kind of
scary.
see how you think and everything. But if I'm not gonna pick someone who, like you said, lives in Howard Beach, probably has 4 people in law enforcement. So now I'm already judging you like, oh, you're ultra
I think we need to
conservative.
flesh
and,
that out.
like, so
I think we all know what that's hitting
Why?
for.
But why?
But
Why?
why?
Why? Because let me
what
tell-
is?
Let me tell you why.
Yeah.
Let me
What
tell you
is
why.
where you live?
Because
what does that apply?
Because if you and this doesn't apply to Queens, but like you're from Staten Island. Staten Island is like, pro-Trump. Let's not fuck around. That's the only borough here in New York City that's like pro-Trump. And you don't want a person who's going to judge you based on the color of your skin, based on whether or not you have an accent, based on all of that. And they are taught, as a police officer, you come home, and what is the first thing that you do to your significant other? Well, actually, as a police officer, anyone. What is the first thing you do?
Tell 'em about
Hey,
your
honey,
day.
how was your day?
yeah, how was your day?
How was your day?
Yeah, so you hear about all the crazy
All
stories
the time.
and how hard their job
Exactly.
is.
So
how
you already,
complicated it is.
we all have biases. Let's not mess around with that. We
Right.
all have biases.
Exactly.
And that's why we do the deselection process.
Right.
Because,
I think
if
that's-
you're married to a police officer, you hear your partner talking as if everything that he says is true.
Right, exactly.
And they have a different idea of what they did in the day. Yeah, I arrested these 2 kids. They were in the train. They were, dancing and shit.
Yeah.
I didn't say. He doesn't say that. These kids, wearing.
But-
To
but-
us, that's normal. To them, it's not.
But the key is though, like you have to know your case, right? And like this is why we say like we were joking, but like we really mean it. Like you're cool, like we like you jurors, but you're just not good for this case,
Yeah.
right? Because
No, that's true.
if the whole crux of my case depends on me discrediting the police, you're not a good juror for me. So I have to get rid of you.
If you
If you have
have
family
a bias,
members,
a favorable bias,
A
to the
favorable
police.
bias.
Exactly.
And if you have don't
And
get me
it-
wrong.
it-
Don't get me
it's
wrong.
both
I
ways.
have people in my jury who have police officer family members.
Yeah.
I've had.
And they-
I've had that, and they're
Exactly, yeah.
great.
exactly.
So honestly, it is a hunch.
Right.
I'm gonna
It's a
say
hunch.
that. It's a hunch.
And I'll
that
say
you
that too
get.
because
Go
I'll say
ahead.
I'll say that too because like I have plenty of family members in law enforcement, So and for me to say that, obviously I'm going against what I think,
Yeah.
what we do during voir dire, but I have family members
Let
in
me
law
ask you this,
enforcement,
Eugene.
but I know that
Corrections
I'm
officers.
not
Correction officers.
biased,
Correction
to
officers are super hood.
So you will want him in your jury?
I would want a correction officer. 'Cause
I
I
feel-
know a lot of correction officers. Like correction officers, like I'm not gonna say. trying to say this in the most. A lot of correctional officers I know personally come from the same communities
that you come from. That
come.
your
Like
our
I feel like
clients come
I feel like the representation, like correctional officers, represent the community they correct. Like they monitor in corrections at a higher rate than police officers, in my opinion.
Well, it's community
It's
policing
well,
is
not
strong, but
even
that's another
that. But
episode.
I mean,
think
listen,
so.
if you notice, the correction officers, most of them are black. You know, they're like most of them, like if not all of them, are black.
It depends where you go again.
You see a white correction officer?
Yes.
Wow.
I mean,
I've
thought
seen
it was
two
Suffolk
officers
County.
in Queens.
Suffolk
In
County.
Queens, there's
I
white.
said it depends where
Alright,
you go.
yeah.
Yeah.
Here
I
in New
know
York
what you're
City,
saying.
they're
They're
black.
more
Like, court
representative.
officers
They're more
are-
representative of the communities that we serve.
Right.
I just want to make a point, but just so jurors know, like, I guess we've all been saying the same thing. Is like, don't be offended. Like, if you're biased,
I mean, you can be
that's how you
offended unless you're in my jury.
Okay, no, be offended actually. But if you're biased to something, then why would you sit through a trial
Yeah.
when you hate somebody and don't sit through a trial when you
Hate's too strong a word. I mean, we need you to be ultra neutral and just
Nah, finish your thought.
favoring and not
No,
favoring
sit through
someone
a
is
trial
too
that
much.
you can actually do. That's what he
Yeah.
means.
Yeah.
that
Don't
you're
see
not
to a
biased.
trial that you're biased because that might
Yeah.
reflect bad on your decision making.
But I'm
That's
just
what
saying
he's
that
trying to
hate
say.
That's
is
what I'm
the
saying.
strongest version of
I
bias.
hate when people say hate is a strong word. By whose definition? By your definition? I understood hate.
What's
to be
above hate?
There's more. Like
Really hate?
no, there's hate.
There's
Like I hate
levels
that.
of hate.
Oh yes.
Definitely levels
Yo,
of
like,
hate.
I know what Jubril's saying though. I know what Jubril's saying. Like, you might not be good for this case. You know, it's like the person who has been robbed before. They might not be a good juror for this case, but they might be juror for a DWI.
I want to go into preemptories and for causes, and I'm going to use a story to get this there because I sat on a murder trial. They definitely ran out of their
Peremptories. But you need that.
Right, they definitely ran out
You
of them,
need
and
to-
I
you
want
need
you to
to- you need
explain
for
that.
appeal.
And the reason why I know they ran out because my questioning was bananas. Because they're literally like, "Have you been a victim of crime?" Yes. How many crimes? Oh, I got jumped like 5 times. So I go, okay, so you're the victim of crime, so like, you have a sense of like loyalty to like who should have stopped those crimes, police, right? And it was like, but do you have anyone in your family who's been convicted of a crime? Oh yeah, I have someone in my family convicted. So like, I was like, I had a lot to go both directions, and they kept saying like, well, can you be neutral? And I was like, yeah, because the family member who committed the crime, he committed the crime. He did the bid that he deserved to get. Like
You deserve that
I
shit.
would have hoped he didn't get it, right? But at the end of the day, it's not like he's fucking innocent. And the people who committed the crimes against me, they deserve to get arrested, but they didn't, right?
It's like for every action, there's a reaction.
Yeah,
There's
like-
a consequence.
Like I like cops. I live in the Bronx. Keep copping the Bronx. I like it. Don't worry about it.
That's the Bronx without cops.
Imagine the Bronx without cops. Yes. So I somehow made it to that fucking jury. I was an alternate, so I think
You didn't make it to the deliberation room, but
I
you
did.
were there
Yeah,
throughout
but
the whole trial.
so to get more,
That's what an
to
outcome
get
is.
more of an like something that's like, because I think any person who experienced jury as a juror understands what you're talking about. To get more from the legal side of it, can you go over preempts? Can you go over for causes? Can you go over
The bad-
misdemeanor,
Yeah.
felony?
Okay,
and,
the breakdown. The breakdown.
break it all down.
I feel like this. So it just depends on the type of case, right? So there's breakdowns. So peremptory challenges are the challenges that you can use just because. You know,
get rid
for
of
example,
jurors.
to get rid of jurors, the deselection of the jurors. So
Yes.
just because, I call them just because challenges.
Without having to explain.
Without having
anything.
to explain to the judge why you are deselecting this person, why you want him crossed out. Those are the peremptory.
And how many
challenges.
of those you have?
Well,
depending
I'm
on
gonna
the
tell you.
case?
I'm gonna tell you.
Wait,
So
so
if you
sorry to cut you off. So basically, I can, if I have Eugene on my jury and I look at that T-shirt.
Wow!
I'm just
Yeah,
like,
you don't
T-shirt
like
for
Hawaii.
the-
Alright, fine.
And you don't like Hawaii. You
I
can
don't-
cross them out.
Exactly. Or I don't like
Yeah.
those sneakers. And I'm like, what are
You get
those?
them out of there. You get them out of
If
there.
I do that, I'm
Yeah.
like, get out of here.
Yeah, you can get them out. X them out. Or if you look at Ev. And
You're
you're
not like the part of
"I
my
wanna
hair
hand
either."
to you.
That's what I was
I
like,
happen
get
to
him
like
out of here.
Hampton you, but if somebody don't like Hampton you because
Exactly.
they had a bad feeling about their football game, they lost
Yes.
to Everett, boom.
And I don't
Get
need
him out.
an excuse. I
Don't
don't need
think.
to tell the judge.
The
any-
judge
any
don't
reason.
say anything.
Get him
Alright,
out
so
of
that's what a peremptory challenge is.
And
So
how many you
with an
have,
A-
depending on the case?
Okay. You charged with an A felony. You don't want to be charged with an A felony.
Yeah, you do
20.
not.
You have 20
You have
peremptories?
20 peremptory
Shit, I didn't
challenges.
know that.
20.
I would know it if it came up, but it just hadn't come up.
It hasn't come up for G. C and a B. You guys can help me. How many C and a B? 15. I mean, just keep subtracting
going.
5, brother. C and a B. 15 peremptories.
And when you say C and a B, you mean felonies.
Felonies.
B felonies.
This is only felonies.
Yeah.
D and an E. 10.
10.
Peanut gallery. 10.
We don't do math,
Misdemeanors?
man. We don't do math. We're bad with math.
Misdemeanors. Fuck that math. 3.
Dirty.
Yeah.
Okay.
3, bro. And you know, misdemeanors, jury trials, honestly, they're luck of the draw. You've tried a misdemeanor trial case, right?
Yes.
How many were in the box? No, I'm fucking out of here. How many were in the
Why
box?
you
You
so
try,
laughing?
yo, how many were in the box?
There's 12. They fill it up. They fill up the box. So, but
How
then-
many are selected?
But you only get 6.
Exactly.
And maybe an alternate or 2.
Six, and maybe one alternate. But it's because misdemeanor trials are fast. They happen in 3-4 days, so you don't need more than one alternate. If that.
Let me ask you a question. Can there ever be 12 for a misdemeanor? 12 jurors for a misdemeanor.
I've never seen it.
What if the misdemeanor is indicted?
Yes.
I've never seen it.
Ding, 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 I gotta answer that one.
I don't know. I've never
If
seen
you
it.
indict a misdemeanor, you get Supreme Court rules. I don't know why a DA gonna do that.
Why
An ADA gonna do that.
No,
but if they do it.
I know why DA don't do that. You don't want that fucking many jurors out there. Like, wait,
No. But if you end up
It's more work.
the indictment process, which we're not gonna check the citation, right? The indictment process, it's somewhere.
It's like
The indictment process takes that criminal court case, which is misdemeanor land,
And puts it in
and it'll
Superior
bring it
Court.
to Supreme Court. So it's like it doesn't. Typically, the charge is what gets you more jurors or not more jurors.
It is,
But
usually.
if you treat a misdemeanor like a felony, it'll get you more jurors. Haha, I knew that. Fuck you guys.
Yo, he knew it.
Now, go ahead. All right.
No,
so
so,
now
like,
you did preemptories, right? Now, before
Well,
you
before
move,
you do preempt.
before you move from preemptories and you go to for causes.
Well, that's
not
before
all
that.
preemptories work like that because they're
Correct.
Batsons, right?
Exactly.
Well, no,
So-
before, hold on. You get too ahead of yourself.
Okay.
For cause challenges are the kind
I'm-
of challenges that I said that I
I'm
was trying to
sorry.
get. So the people that don't understand the law, people who don't speak English, that's one way to get out of jury duty, by the way. It's like, I don't know English. Or
This is
like,
not
you know,
legal advice.
Hey, no, nothing is legal advice
Okay.
here, but it is advice if you really want to do something worthwhile with your time instead of sitting in a fucking room.
Our recommendation.
No English.
Not
Well,
legally.
those are for cause, actual cause. Oh, there's a cause to excuse this juror.
Okay.
And they give him something, they're like, yeah, here it is. Maybe you are better off in civil court. That's how it is. And then we get to Batson, which is huge.
Oh yeah, so I was gonna ask, Mr. Garcia. So if I want to get rid of a juror because they're black,
Well,
Can I
you're
do that?
fine if you do 1, 2. The third time is a charm. No, but it is the truth. It is. No, it is. It's the truth.
You wanna
It's
get
not a
rid of
joke.
all the black, but that
No,
is
no,
true.
it
Yeah,
is
that
not. It is not. It's not a joke. It's the truth, man. Because you
is
can
true.
keep getting,
Yeah.
get rid of the blacks. 1,
Right.
2.
Yeah.
Third time, then if you have a good defense, and yo, hold on a minute. If the defense attorney is bad, then it's like okay.
So I mean,
Yeah.
explain
It's on the issue
mechanics
of race.
how that would work.
The Batson challenge is when they get rid of a juror based solely on race.
No, but
And now it is.
no, I know that. But
No,
I guess I feel like there's a lot being unsaid, which is that how mechanically how would that work? right?
Mechanically, you see, as a defense attorney, you're sitting down.
Yes.
And you see the prosecutor going, okay, juror number 2, I want him out. And as a defense attorney, you notice, okay, this person's black. You go like, okay, the third juror, I want him in. Fourth juror, I want him in. And you see, okay, there's an Asian, there's a white. Fifth, I want him in. It's a Hispanic. You get to the sixth juror, it's like, no, I want him out. Okay, that's the second black they're striking. So now you're saying, okay, there's something going on here. They're using the race of the juror to strike him out. And then when you get, okay, 7th, 8th, they're not black. 9th, they're not black. 10th, they're black. Boom. Then you go, Your Honor, they're striking jurors based on the issue of race. So what happens is you have to let him, the judge know, look, judge, number 3, number 6, and number 10, they're all black. And this DA is striking them solely because of race. Right. Then the district attorney has to say something about why they're striking each juror, and especially the last one in particular, why they're striking them with
Not
something
based
that
on
has
nothing to do with their race.
Right. So okay, maybe he has a family member who was convicted of a crime, and then the judge decides. And then it's up to
And to be clear, this goes both ways.
it
So,
goes
for example,
both.
like,
That's what I was gonna get
you
to.
start striking
That's what I was gonna
every
get to.
white
If you
juror,
start striking every white juror, it's what you call reverse challenge. So reverse Batson challenge. So the district attorney can actually use that against you as well. So it's not, you have to be very careful of why you striking the jurors and the real reasons why. So you can't do it on the base of race. I know, just talking about what happened to me. I won a Batson challenge in one of my jury trials, and it was because the DA was striking out the African Americans from the panel. And from,
Did you
when
fight
they were
him
sitting.
or her?
Yeah, I know. Well, I did. I raised it up to the judge. And
Nah,
then,
talking about physics.
no, I wouldn't.
That's how you settle stuff in court.
Is that what you got? That's what you haven't been selected as a juror.
That's what
No,
happened.
no, no, no,
That
no,
didn't
no,
make
fine.
you mad?
It made me upset. It made me very upset. But you know what? I told the judge, and the judge actually agreed with me. And he asked the DA, "Why are you striking these people?" And she
couldn't
really
explain
couldn't
it?
say it. Well, in essence,
Man, that's
I
crazy.
don't want to
She
get
couldn't
into
think
it,
of a
but what
reason.
she said is like, this person is, she's a chef. She is she's a chef in this restaurant, and she has orange hair, so she is less likely to, conform with authority, which was messed up because that was her regular
Yeah,
hair,
that's wild.
and the DA didn't know that. So it's like, you're striking out.
Regular hair was orange?
Well, it's not orange, but it was a regular natural hair color. It wasn't orange. She said orange because to her, in her perception
Was
as
she like a blonde or something? Like
no, she was an African American female with lighter hair, like reddish hair, like
Oh.
And the
This is
DA,
a dead one.
the DA was like, "Yo, her hair is orange," and I was like, "This is just a regular African American."
So
Like
she's saying that black folks don't have orange hair?
yes, yes,
Do we
and
have
she
orange
was saying that.
Well, what color was the hair?
We got orange
Oh, it
hair?
wasn't orange, bro. It wasn't fucking orange.
You know any black women with orange hair?
I'm fucking
Well,
confused
she didn't
as
either.
fuck right now.
I don't know.
Shit.
All I know is that it wasn't orange. Like you see all these things. You see it back there? It wasn't orange. It was regular hair to the white girl. It was orange.
Okay. Hey, it is what it is.
Damn.
Maybe she was colorblind. I don't know.
Okay, all right. Woo. I get what you're
Anyways,
saying.
that was her excuse to dismiss her.
Yeah.
That was
But-
oh,
That
yeah,
that was
it
her
is.
excuse.
Oh, okay.
No, but
See,
that
now
was
I get it.
That's what she told the
She looked like a
judge.
fucking idiot to the judge because
Yeah.
you're reaching. What?
Exactly.
You fucking your cause was her orange hair. What the fuck does that mean for anything?
Yeah,
Okay.
That's the week.
Well,
That was
yeah, whatever. So that's what it was. That's a Batson right there.
Okay.
But I can use it against us also. So you have to keep that in mind. So that's jury selection. But before that is Sandoval. It's very important because preliminary Sandoval means all the past crimes that you have done, and you have a guy with a long rap sheet or a lot of crimes that he has done and convictions. They can use that against him if they take the stand. That's the good
Yes.
thing about Sandoval. All right, let's say I have a history. I'm on trial, and I choose to take the stand. Sandoval allows the district attorney to ask me about my priors, everything
When you
that I've done
understand.
wrong. Priors means
Prior
like
convicted
every
crimes.
my arrest, my conviction for whatever the hell I have.
And just he's saying Sandoval. That's
the case.
That's the case that
Yeah.
decided that this is how it's gonna work.
Yeah.
Moving forward, when he says Sandoval, that's just short term for citation right there.
Yes, there's people be Sandoval.
Jab-
you know?
Jabra-
Right?
Jab-
Like,
Jabril pointed first, so he'll write that one.
yeah. Jubril won't like this. Well, no. But it's, like the
Yeah.
way it's easier to explain is like beginning of trial, Sandoval, Molyneux, then Voir. Like that's why I want to make it clear. Sandoval, Molyneux, Voir.
Okay, so Sandoval
So,
goes
Molyneux.
if you testify.
Yeah, if you testify. Molyneux is the instances where the prosecutor can actually bring past things that you have done that are bad,
Right. Not necessarily crimes.
not necessarily
but just
crimes,
bad acts.
behavior, bad acts, exactly what F says, into the trial without you testifying.
All right,
That's the key thing.
So before we get to when they can do it, why can't they typically do it? What is the court system worried about?
Well, the court system is worried about propensity evidence.
And what is that?
Propensity is the key word. Propensity means if you do something wrong, that's likely for you to do it again and again and again and again and again.
And the court system wants to avoid it.
Avoid it. Yes,
and
of
why do
course.
they want to
For
avoid it?
prejudice.
Yes.
They don't want jurors to be prejudiced just because, like, oh, this guy, he went in the store and acted crazy 5 times
Yeah.
before in the past. So he's in the same store this time and on trial, so he must have done it again.
You don't
know,
want to
that's what you
convict a
don't want.
person based on that. That's correct. You don't want to convict and say this person is guilty just because he's done it in the past.
Basically, you don't want to say this guy's a dickhead in this situation because he was a dickhead in the previous situation.
Yes.
Correct.
Correct.
You want to try him on what he did right now.
Then, yes, exactly.
Beyond a reasonable doubt, which
Yes.
is the standard
Beyond-
kind of we
Yeah.
haven't established, but basically, you want to sit there and say, you want a jury to believe that this person did this thing on this date, the specific crime that they're being charged with. You want them to believe it beyond a reasonable doubt. And you don't want them to sit there and go, he's typically committing crimes. If I believe, if beyond a reasonable doubt, which you can't actually quantify,
Yeah,
it's
beyond a reasonable
80%
doubt.
or whatever fucking it's conviction,
Yeah.
convincing of yourself, right? You don't want to sit there and go, I'm not there, but he's a criminal, so he's
Yeah,
probably
exactly. You don't want to use that against them in this
Exactly.
trial. You want a juror to be like, okay, this is where it starts, this is where it ends. When he got arrested to when he's facing trial, you don't want him to go before when he got arrested for this crime.
But you can, under
Yeah,
certain
you
circumstances,
can
which are.
It's called. I call it mimic. I don't know if you guys have heard
I've
of
heard
mimic,
that, yeah.
right? Like it's like all defense attorneys here mimic.
Motive,
Motive,
identity.
identity, mistake or absence of, right?
That's called prep.
Intent. That's called mimic. Intent and a common scheme or plan.
Okay, so
Which
let's
is
try to
your-
go through
yeah.
some of these.
So, what was the first one I said? No. So mistake or absence of is no, actually, yeah, mistake or absence of is like when you say there wasn't me, but you've done it in the past. Your defense is gonna be a mistake, like yo, is somebody else not me? Boom, mistake. They can. Let me just think about this. Like for example, you haven't cashed a forced check. You've done it before, and you're like, okay, that's not a mistake because you've done it before. They can use that against you.
Basically, the argument is that you're sitting there
It's-
going, someone could be caught in this situation by accident, but you don't fit that criteria because you got caught doing it legit. Like you got caught and convicted previously, or caught at least arrested several times. That it's no, because you've been in this situation so many
Like, you
times.
don't know how
it's
it
no
is.
longer
Yeah.
an accident.
Yeah, like you don't know how it's done. For example.
Exactly.
That's your identity. We all know what it is.
Well, sure.
Oh, identity. Okay, identity is like
It wasn't me.
it wasn't me. Like Shaggy.
Yeah.
That's identity.
And but how would, I guess,
Right?
how would they
You on
get?
camera?
How would they get a prior bad act in?
You can say, you know, like I was not the one robbing the supermarket, and it's a video of the, you know, they see you, and it's like the same thing. You look the
You've
same.
been
you
there
wear the same-
previously.
Yeah, exactly.
Okay.
All right. Motive. Motive is, you know, you have a motive to do this one time. For example, you know, I have a motive. Let's take it up a notch. I have a motive to kill my last wife because of her life insurance. You know, and then you do it again. Boom. Motive. You have a motive to do it a second time. They can introduce that again. They have to show a lot more than that, but that's in essence what it is.
Okay.
All right. Intent. When you say I did not intend to steal that from the store.
They
But
could
you
bring
have
in the
done
fact
it
that you have the
before.
life insurance.
Because it's the same. You can say the
Yeah.
same thing about
Yeah.
that. Yeah, I did not intend to.
They're
you know,
similar. They're all
It's very similar. And the common scheme or plan is, you know, we all know it's easy. Serial killers. Common scheme. You
Or
leave-
bank robbers.
Bank robbers. Serial killers. You keep, you know, like a little something about someone you kill, and you keep. It's common scheme. They have the signature. The Zodiac killer. They have the. You know, it's the same scheme. They do it the same
They
every
commit- they com-
single
they commit
time.
a
The
certain-
same crime.
Right. They commit
They-
a certain crime.
Like you're basically you. I want to like explain it further. Is that they're gonna allow this evidence in, right? Because what they're gonna say is that we don't want you to judge him that he robbed a bank previously. What we want you to consider is that when he robs a bank,
This is how he does.
this is how he
Yes,
does it.
exactly.
He gets a note. He tries to keep violence out of it.
He
by,
signs the same signature.
Yeah.
It's
Or like a good example
Yeah.
is like you give a note saying, "I have a bomb. Give me the money. Don't say anything." Right? That's a very specific way to commit a bank robbery, right?
Yeah.
You avoid having to bring a gun. You avoid all this stuff. You just make a very serious threat. That's how you commit it. You hope the person that you give it to like freezes
Yeah.
and just hands you money. That's the way you. That's the
You
way
do
that-
things.
That's the way you do things,
And
and
they
because
know
you've
it.
done it in the past and
Yeah.
you did it in this case, the prosecutor is basically arguing that we're not saying convict him because he did it. He's committed a crime. We're
But just
saying
keep in mind that.
that this is how he does
I mean,
it. It's
in
consistent
essence-
with what he did in the past.
In essence, that's what they want you to. I mean,
Yeah,
it's
yeah.
still.
They want
All I
you
know
to
is
do
very
that.
prejudicial.
Yeah,
in
it
many
is,
ways.
but
that's their way they get it into the case without our client testifying. The way they want to, you know, like. You know,
Okay.
so it's, but it's a way. So then, okay, we then after that is jury selection. We spoke about it, and then it's opening statements.
Okay.
Opening statements. One thing that you have to keep in mind is that in our criminal justice system here in New York, it's different in other states. The prosecutor starts and the prosecutor ends. The first thing that you hear is the DA. The last thing that you hear is the DA.
why is that? And also go into the Why is that? And also go into the fact that opening statement is not evidence.
Yeah. Well, why is that? I don't fucking know. Now I'm telling you this. Why is that? Is because the DA has the burden.
Yes.
Right.
But that's what they. In reality, you know, it is that. In some states, you have the possibility, you know, to finish. In summation, they go DA first, then the defense, and then they have a little time for rebuttal. So it's just it varies by state.
Okay.
Virginia is one of the states that allows a rebuttal.
I don't know shit about shit in Virginia.
No, Virginia.
I don't
I
know
mean,
why you pointed
so-
to
Yeah, that's what I mean.
That's what
That's why I
So
point to
before we-
him. And to you.
Well,
Virginia
I thought you
allows
said
a
about Long
rebuttal
Island.
by the DA. But the defense goes second.
Of rebuttal to the
The
defense's
yes.
argument. Right?
But that's
Now,
why in every jurisdiction the DA goes last because they
Now-
have their burden, their job. Their job.
So let's just talk New York. Prosecutor does their opening statement.
Uh-huh.
We've already established it's not evidence, right?
It's not
There are
evidence.
certain elements that opening is required to have as a prosecutor that doesn't actually correlate to what a defense attorney has to say.
Yeah.
Defense attorney has no responsibility to say anything in their opening. They don't even have to do an opening.
They
but
don't,
the prosecutor, if they're going to do, the prosecutor has to do an
Has to
opening,
do.
and they also have to establish certain things, right? They have to establish the fact that the crime was in the jurisdiction, the time, the date.
I mean,
and
in
they have to-
reality-
they have to say the burden, right? I believe they
Yeah,
have to
well,
say
well,
the
in
burden.
yeah. I mean, in reality, the DA is going to tell you in opening statement usually what they plan to prove in the case, and that's why defense attorneys it should pay attention to opening statement because
course.
they give you a map of what they're going to prove, and usually also DAs point a finger, say this person did it, opening statement, and you can use that against them a lot of times. But defense attorneys don't need to do that because, again, you say that the job is not on ours. The job is on them to do it and to prove a case beyond a reasonable doubt. And they have to tell you, it was done, it was committed in Queens, what they did, and all of that. And then it's up to us to either respond if we want to or not, right? The defense attorney, usually, I tell people, do an opening statement, but do it very, it's just kind of like a blanket. Don't go in depth as to everything else. Just like
And
blanket
why?
opening statement. Because you don't want to commit to something that you are going to do, and because you have nothing to prove. If you commit too much, then the jury is expecting you to do something that you don't need to do. And what you have to think about is that in a criminal case, the defense attorney doesn't have to prove or disprove anything.
Why is that?
Is because of the standard in our law. The standard is beyond a reasonable doubt. The prosecution has a job to bring forth the evidence and prove to you the case. You said it, beyond a reasonable doubt. The defense attorney, it's hard to explain it.
Yes.
There's
no one standard
There's no
definition.
one standard. I mean, what the judge will tell you is that a reasonable doubt can come from low quality evidence as well as the lack of evidence.
Okay.
So, and that's actually, in my opinion, the most defined that we will get this term reasonable doubt. Because if you have any doubt based on the low quality of the evidence that is presented to you, as well as the lack of evidence, meaning was there surveillance? Was it this? Did the cops go to the scene?
Where was this
I mean,
witness?
look, exactly.
That witness was missing.
If you have any doubt based on that, then that's a reasonable doubt.
Now, as a defense attorney or even a prosecutor, can you get in trouble or be told not to speak about the term reasonable doubt in any way, shape, or form? Like, is there a way you can and cannot talk about it?
Yes, I mean, first of all, during opening statements, you kind of have, like I said, you have a little blanket policy of just, saying what the case is about without really getting in depth. The judge will, it differs. Judges sometimes do, sometimes don't, but don't try to explain the law that the judge is going to give them. That's what you're going to get every single time. I tend to do that a lot because I want to educate the jury that this is not like the real world. This room is this room. When you get outside, it's when you get outside. It's a completely different deal. So I tend to try to explain more so they can get it. But you're right, you can get in a lot of trouble. So it depends on your defense. I think I think people should think of a case in the terms of explaining to a jury the principles of law. That's what I call them, the principles of law. Beyond a reasonable doubt, burden of proof, low quality and quality evidence. I call the fourth one I do is speculation, because the judge will tell you cannot speculate. You cannot guess. You cannot fill any holes for the district attorney. And then you go into what you said. For example, your defense. What's your defense in a DWI? This person was not intoxicated.
He was
Margin
tired.
of error. Machines make mistakes. What's your defense in a self-defense case? Do you have a right to defend yourself? Yes, you do. When do you have it? So that's the difference between both things that you tackle voir dire. And I think that's what you were asking me. In terms
Okay,
of
so now let's get back. No, go ahead. I apologize.
So, but like, for people to understand, like, why wouldn't a defense attorney then put on a case? Like, why wouldn't you? Like, I know it's the prosecution's burden and they go first, but like, why wouldn't a defense attorney not say anything or put on a case? Like, you know, for those jurors who sit there and it's like, I was waiting for you to talk and say this and say that. Why won't they do it?
Because they burden shit. I mean,
they do, and
do.
that's
They're
why
not supposed to.
it's so important to select a jury that knows and is educated enough to know that in our standard of law, we have what is called the presumption of innocence. Right?
Okay,
And-
go into
and I'm gonna tell you, it's a hard term to actually put into mind, but you are presumed innocent, right? And that is the reason why when you arraign, you plead no guilty. When you get arraigned on an indictment, you plead no guilty. And what people need to understand is the person sitting here to my left, for example, if I'm a defense attorney, they've been going through a lot of waves, as I call it, and they've been maintaining their not guilty all throughout. So as they sit at that table, they are presumed innocent. And if the people want to change that, right? If the DA wants to change that, they have to provide evidence and proof. And that is why, is because our system of law is built like that. It's built to protect an innocent person from going to jail, right? And that's what we've heard time and time again, right?
Right.
That is bet-
But then that's what
So
I'm
I
saying.
actually think there's a good story that explains this point, right?
But why?
It's something that you would do in jury selection, which is this kind of concept that you have a child, a parent, every morning this child wakes up, doesn't clean his bed, right? Comes downstairs to have breakfast before he goes to school. Mom goes upstairs after the child goes to school. The bed is unclean. First time, what the fuck? Clean your bed. Second time, what the fuck? Cleans your bed, right? Third time, kid gets it. Kid cleans his bed, right? Cleans his bed, fixes it. Goes downstairs, has breakfast. Their dog,
I talk about the
ju-
dog.
the
example.
dog
I know
goes
that.
into the bed, fucks it up, right? Now the kid, the first time, got pressed by the parent. Let's say the first time the kid says, "Oh, I cleaned it," but the mom knows he didn't. He goes, "All right, I didn't clean it." Second time, same shit. Like, right? Because kids sometimes lie about bullshit, right? The third time, when he legitimately
does it.
cleaned it, and he doesn't even know how the bed got fucked up because he's not even that smart. The question becomes, how does that kid in that moment prove his innocence? Is his, what is it? You test too much. Like, what is the phrase? Like,
But that's the thing. You don't
Like-
have to prove your innocence. That's
Well, I'm
what
saying,
you have
some-
to explain to the jury. I think that's
Legally,
what you.
Legally.
shouldn't have to.
That's what I mean when
But-
they come outside.
but
to
sometimes
the
you
court.
can't.
We know
the
that,
whole
like-
point of that is like sometimes you can't prove your innocence.
Yeah, sometimes you can't.
I mean,
But
You know what I'm
like,
trying to say? Like,
yeah,
that's
most
why.
of the
That's
time
why.
I don't. Most of the time, you know, I mean, it just depends on how you prepare the case.
Yeah.
The way I prepare a case, like my client is not testifying unless he absolutely has to.
Yeah, exactly.
Right? And that's, I think that in a way, we have to start thinking about the criminal justice system as a different type of beast than the outside world, right? Because I think that when people come to a trial, they think in a way that this is the way it has to be, like the real world. But you, in essence, when you are in there, you have to let them know that this is not how it goes.
Right. I mean,
And
like,
this is not how it goes because you cannot, you should not prove yourself innocent because of the system.
Right.
The system and everything is against you.
right.
So if they're the ones bringing the charges, they have to tell and show and make sure they have the right person. That's who their job is.
Right. In this little legal world.
Exactly.
I
Yeah.
agree. Like, so, like in Eugene's example or hypothetical, I don't know, was it
It's a hypo, and I've
Was
heard
it you?
before.
And-
It was a hypo. I've heard.
Baby
it
Gene.
before. I've heard it before. It's a good hypo, you know. It's,
In that hypo, like now you put your client on the stand or you put on a case. There's not really much
Why?
to
Yeah.
put. Like he's just gonna
Why?
say, "I didn't do it,"
Right. That's
and
all I was
then
gonna say. Because he doesn't know how it got done.
that's it.
Yeah.
He doesn't even know the dog did.
that's what I'm telling you.
Yeah,
But then-
and
but
to a
then-
certain extent, to a certain extent, you could almost make an innocent person sound guilty when their excuses don't sound reasonable.
Yes.
Because when you're sitting there going,
I made the bed.
I made the bed.
Well,
like,
and that-
you just sound, but okay, but what, you know what the parent knows? You know what the jury knows? The bed wasn't, a bed was not found
Right.
made.
But
You're
that's
not-
what-
yeah, exactly.
So there's a dead person in his house. Yeah, I didn't, but I guess the question, it becomes a thing where it's like, how effective is just screaming to a jury, I didn't kill the person?
But that's what I mean. Like
Right.
that's what you know. For example, let's say you care about that. You tackle that voir dire. You go, can you tell me why a person who is innocent wouldn't testify?
Mhm.
And they will tell you. I mean, you can kind of guide them. You know, they're
Yeah,
nervous.
sometimes
They're
they
just
get
no
in-
good in front of people.
Mhm.
You know, I, as a defense attorney, tell you, look, they haven't done their job. Your job, you don't need to do anything because of your Fifth Amendment. And, you know, I'm sure you guys will get to that at some point, but like, you know, like
and,
it's,
and then like imagine like in that situation where like the stuff you say like mimic or like common
Yeah.
scheme like something what
Well,
if
that
the
might be
last two
before that, yeah.
incidents of him not making the bed come in
Yeah.
and now it's like
Yeah.
so he's definitely going to be found guilty in that situation.
Well, that's
like,
the concern, yeah.
you know that's I mean but like it's more likely than
Like-
not because that's what that stuff does.
you have to understand
in
that,
that
you know, the
situation.
system as a whole, it was built of, I rather a guilty person goes free than, 100 people, that.
That's
you know.
what it's supposed
That's
to
what it's
be.
supposed to be,
Yeah,
but it's not.
but it's
That's
I
not.
think he's gonna finish that sentence, right?
Yeah.
You'd
Should
rather,
finish that sentence.
you would rather 1,000 guilty
No, guilty-
people go free than one innocent person get convicted.
Yes.
Basically.
And it's,
Because there's a
it's-
greater
that's-
injustice in a society
Yes.
by
But that's
having
not how
an
it
innocent
is.
person be convicted and sentenced to a crime.
And I
they
think that was the
committed.
idea behind it, but that's not really how it is now.
Our system is built on the premise that if you're arrested, you're guilty of something, right? We give police officers a lot of leeway where they're not viewed as making mistakes, as a society. Just
That's
my
true.
opinion.
No,
This
it's
is
true.
my
You're
opinion.
completely
We
telling the
like
truth
we
like that.
live in a society where we believe police officers.
We give a little deference.
We give them more deference, although, and again, this is in the legal world, a judge is going to instruct you that just because someone takes a stand in a badge, in a uniform, and is a police officer, doesn't mean that they're more credible or less credible than someone who's a layperson, right? We instruct the juries on that, but in reality, when you have people come in, whatever rank police officer they are, whether they're a captain, a sergeant, whatever,
In uniform with a
in
badge.
uniform with a badge, and they say they saw something and they did this and that, and according to protocol, they do this and that, they're going to be given more credibility than if the defense calls another witness, maybe a 13-year-old kid who's just walking from school and happened to see something and is like, oh yeah, that guy didn't do anything. That's just the facts. That's just the way it is. That's just the world we live in.
You're right.
You
And
know?
I think it's because of the world that we live in, and we give a lot of deference to authority.
We do. I
We
mean,
do. From when we're little.
Society does, not me.
I'm talking about we as a
Joking.
society.
Yes.
When
Alright.
you're misbehaving in
So-
preschool, something like
Let's-
you say like.
So now,
Yeah,
if, as a defense attorney, right? If you're gonna do an opening, what are the things you're hammering home?
reasonable doubt, baby.
Yeah.
Reasonable doubt.
That, I'm with Ev, right? Like
Reasonable
you
doubt.
do the principles of law.
Right.
That's what you do.
It's hard
you,
to
you,
like.
you go into what they're going to hear a little bit,
Mhm.
and for most of the opening statement, you go into the principles of law because you know what repetition is the key to success. And they will
Yes.
hear time and time again, reasonable doubt, and it will get in their ear what reasonable doubt is.
And what is
Yeah.
reasonable doubt?
That's, nobody fucking knows. Low quality evidence was the lack of evidence, and what I say is any doubt, but they don't think it's any doubt. It's any doubt that can come from low quality evidence as well, and lack of evidence. That's really defined in New York.
I don't have a
It's
blanket
hard.
statement for
It's hard.
reasonable doubt.
It's hard.
It kind of gets molded based on the case, and then I kind of mold it based on what the case is, and I'd say that's reasonable doubt if you don't have these elements.
That makes
So
sense.
Mhm.
that's reasonable. That's reasonable.
fact.
Yeah.
Yep. If it's a case where it's like misidentification, and there's no 911 call with any description,
Correct.
Miss idea.
where is that? That say that's reasonable doubt.
Yeah, miss idea is
something
good.
like
Miss
that.
idea is good for us.
Alright, so let's get into actual laying down evidence of a trial.
Mhm.
But something I realized we missed was conceptually, right? A prosecutor's gonna have to prove their case beyond a reasonable doubt. But what that means in itself, so before we get into their case in chief, I want you to just take a couple of seconds to lay out the concept that depending on what you're charged with, will affect the elements that they would have to prove beyond a reasonable doubt. Can you?
What do you mean by that?
So, for example, like an assault case, right? You're gonna have to prove injuries.
Oh
you
yeah,
have to prove
like I mean, it
intent.
just depends. Yeah, depends on the element of the crime.
Yeah, it depends
Right,
on
it depends
that's-
on the crime and on the penal law, you know, depending on, for the penal law, you know, obviously is the law that governs all the penal offenses, you know, when you break the law, it's right there, stop laughing. You know, I know what you,
How old are you?
yeah, how old are you?
You
How
know
old are
what?
you,
I've
Jubril?
never heard it being phrased that
The
way.
penal law?
No, the way you phrased it.
Oh, you know,
Continue.
with an
Penal
accent, you
law.
want an accent?
He said all the penal
The
offenses.
penal law, PL, subsection, section, whatever. That's what it is. That's where all
all I wanted the audience to understand is that depending on the case,
yeah, there's different elements.
be proving the case beyond a reasonable doubt changes, right?
Yeah.
Like they would have to prove that there were actual injuries.
Like in an assault, you gotta prove, you know, that there's an injury. In a DWI, you have to prove that you were driving over the influence of the limit. That's what you're trying to say. Yeah, there's different
Well,
elements.
DWI, you would have to prove that you were actually operating a
vehicle,
vehicle,
yeah.
and while you were operating it, you were under the influence,
Yeah.
right? There's a difference
different
between
difference.
being drunk in a car and operating a car, and
Yeah.
this affects all the elements.
Yeah, you're
All
right.
right. So
So I mean, they have to prove their case differently based on the charges that they bring.
exactly.
That's what they have to do.
So now we're past the openings.
Openings are done. Boom. So the
What's the next day that's
prosecutors-
gonna happen?
The prosecutor, since they have the burden, meaning it's their job, it's their main job to prove the case, they have to bring witnesses.
Okay.
All right, and the way they bring witnesses, you bring the the arresting officer, the victim, the person who this happened to. If there's DNA case, the person who took the DNA swab. They bring just like their case, different witnesses, and they start asking questions, which I call it's direct examinations, what I call open-ended questions. Of
Okay.
what happened, where you used to say why, what, where, how, who.
Okay.
Open-ended questions.
So they have to do open-ended questions.
Why do they have to do it?
Because they can't tell you what to say.
They
You-
can't. They
because
cannot lead the
They
witness.
cannot ask yes or no questions. It's either
But
yes
that-
or no
that's-
questions or open-ended
Why?
questions. Right.
because else they would be testifying
Yes.
themselves.
Exactly.
So
Exactly.
the reason why you're a witness is because you're testifying about what you know. If they're telling you what to say, they weren't there.
Yeah, exactly.
So why are you telling me, the juror, about an offense that allegedly occurred when you weren't there? So I want to take the witness's word for it, not your word, what you took from the witness.
Right.
The witness could have manipulated you, and now you believe the witness. So
Yeah.
now you're trying Eugene based on because you feel some type of way, the way the witness told you about it, and you believe the witness.
Like basically,
They-
do not dress it up them better than what it is. I want to hear it from the witness
Exactly.
firsthand.
Example
Exactly.
would be this, right? A prosecutor cannot ask, didn't you see the defendant point a gun at Mary?
Yeah.
Yeah.
Right? You can't say that because that's leading. The answer is in the question.
He's
But the
telling him,
prosecutor
yeah.
can say, did you see the defendant there?
Yes, I did.
What happened?
What did you
What
see?
did
the
you
defendant
see him do, if anything, right?
I saw him
pull out-
picking his nose.
And my favorite. My favorite.
But no, but it's,
What if
saw-
anything
I
did
saw
he
him pull out his
do
water
when
bottle.
he grabbed the gun?
yeah, I know, you can't say it.
What if anything did he do? No, if he says yeah, he
Yeah.
grabbed the gun. What if anything did he do? What if anything?
What if anything? Did he
opened?
do anything? But my point
What
is,
if anything is
because this is what happens during the trial, and sometimes the prosecutor is taken by surprise because they say, "What did you see?" I saw him grab a knife. Prosecutor's like, "What are you talking about?
It's a
Knife?
good case.
Yeah, what are you talking about?"
So it's a preparation. It's how you prepare your witness. But
So
that is
that's
that is what direct examination is, really.
Yeah. I think there's a deeper legal truth that we're kind of talking about, which is this idea that the jury wants to judge the credibility of the testimony, and that can only be done accurately if the testimony is coming clearly from the witness as compared to being fed to the witness. by the
Exactly.
prosecutor,
Exactly.
That's for sure.
Yeah. Exactly.
Right?
Yeah, you're talking.
And there's the prosecutor does that. They lay out their witness, and the defense has an opportunity to do what? Cross-examination. Can you go into that?
Cross-examination.
It's fun. It's fun
It's
time.
the funnest part of the trial.
Why is that?
You get to ask the witness questions,
All right.
close-ended questions.
And what's the difference between a closed-ended question and
question?
open
Is
question?
you don't want to ask why, what. No, you go like, so last night you were at the bar, right? Yes. You were with your girl. Right? You guys were drinking. You were drinking that. So it's like close-ended questions. My main thing that I learned what a close-ended and an open-ended question was is the close-ended questions end with a period. Always.
Ah.
Always.
Yeah,
If you
don't-
think about a
yeah.
closed-ended, it ends with a period, not with a question.
It's a statement, not a question.
Yes.
But it's just a statement you have to respond to.
Exactly. Well,
It-
they have to respond.
Yeah, they have to respond to.
But in real life, you know, like you're like, the hell are you doing to me? I'm not gonna fucking answer this shit. In the courtroom, if you end with a period, instead of a question mark, it's a closed-ended question.
So let me ask you something, right? A lot of theory with lawyers out there is like, on cross-examination, you shouldn't ask a question you don't know the answer to. Do you believe that is accurate, or like, is that something you learn that you can get away from the more experienced you become?
I think it depends.
Yeah.
I think it depends.
Depending on what, like the witness, or
It depends on the witness, and you know, like
It's a risk-reward situation, right?
Yeah.
You're risking
it
risking
is,
a lot.
Well, actually, if the question, I think I would agree with that, because if the question doesn't really hurt you, but it's just like a normal question that you could gain a lot from. Like if you start cross-examining a witness with a blank sheet of paper, we know people who do that. Well, plenty of attorneys do that.
Yeah.
I've done it before, and the witness gave me gold. You know, but no matter what he said, it wasn't going to hurt me. So I think you're right. I think in a way you shouldn't ask a question that could hurt you in the trial.
Yes.
And when you say, basically,
That could
I hear what
undermine
you're
your
saying,
defense.
but I know that
could undermine your defense.
a lot of my training is allowing me to understand what you're saying. So just to break it down a little bit more,
In lay terms.
basically in more layman's terms, it's this idea that you're not a prosecutor, right? You shouldn't be making this witness's story against your client sound any better than it already sounds. It's de facto, don't ask a question that their answer is going to hurt your client.
Yes.
Right? Is that?
Yes, that's what in reality you're saying. You know, like I think that as defense attorneys in general, we tend to want to hear. I mean, as lawyers in general, we tend to want to hear us speak because we think we're the smartest fucking people in the room. So we want to talk. We want to talk. We want to talk. We want to ask questions. You want to ask questions. You ask me questions all the time. You want to ask questions. You do. You like to hear yourself speak. That's what we became attorneys. We think.
Is that what it is?
Hey, you read my blog post. I said all the stuff you just said, but you know.
Oh,
hey,
well, that's why I'm
nobody
saying it,
will
'cause
read
I
my
read
blog,
it. I
but,
read it. No, but I do think in a way. Do you know when you're a good attorney, when you get something and you're like, I'm gonna leave it alone because they've given me enough, and I don't have to.
And the reason why you're realizing that in that moment, saying less is saying
It's-
more.
Yeah, less is more,
Less is
as
more.
the saying says. Jurors has something to say.
Yeah, no, because I'm incorporating everything you're saying too. But I'm saying, like, you know, when you ask a question you don't know the answer to, sometimes it's gold. But like sometimes you think you know the answer because it's based on your investigation, based on your conversation with the client, based on a bunch of things. But then you ask the witness something that only the witness and maybe your client would know. And the witness just goes there and lies. And the only way you can rebut that is to put your client on the stand. But then it's like Eugene's example. If we put that kid on the stand, what's he gonna say? I did the bed.
Yeah.
So like it's like, but it's like now you ask the mom, did you see him do the bed? And now she's in front of the judge, in front of the jurors, and she's judging herself. I'm a good mom. I would have checked or something. She was like, she might say something crazy that I went and checked, like after he did it, and as soon as he left, I checked the room and the bed was unmade. Like sometimes people say stuff that didn't happen because the jurors are there, the judges are there. So it's like, and the only way, and again, you put your client on, I did it, and that's not true. Mommy wasn't there, and she was downstairs, and like, you know, you're not gonna believe the child. Like it's crazy.
Yeah.
Well, because I think there's a disconnect, right? There's this idea that the truth is not. Sometimes the truth isn't convincing.
Yes.
Sometimes the
that's
truth,
right?
right?
The truth-
Yeah.
sometimes
It's
the
not
truth.
good enough. It's
So
just
it's
You
not
also
good
have to
enough
think about like what
because you're leaving so much out. Like you at that point can't explain how. Well, if you did the fucking bed, why the fuck wasn't it done?
Yeah.
Like you know what I mean? Like if you did the bed, why? Because at that point, then what is the alternative? I'm a fucking crazy ass mother who's fucking lying about my kid making the bed. That's fucking crazy. No one believes that shit.
Yeah.
Right now, if you're smart and you know there's a dog in the house, You might sit there and go, yo, mommy, maybe the fucking was Bucky, the fucking, like, whatever fucking dog name is. Like, that fucking fucked the bed up.
Although that's not the last time you blamed the dog, for something. So,
Hey, the homework.
Yeah.
No,
I'm just saying, but it's like,
Her name is Bucky.
I don't know. It's like, I put myself in a hole in that exact
No,
moment.
what you talking about?
They clearly don't have dogs in the Bronx.
But that's why.
Hey man, I watched
So they
my
got-
dog try to maul a person once.
Y'all
So
got wolves up there. Y'all ain't got no dogs.
Yo, but that's what I'm talking about. Like it just depends. It depends. Like it's
Oh.
that's what cross-examination is.
you do that. The prosecutor does that, witness by witness. Sometimes they
You go in,
omit.
cross.
Oh, they omit physical evidence. They do everything they got to prove their case. You respond to the witnesses they have and the physical evidence. And there's a lot kind of we not skipping over, but there's a lot that you can get lost in the weeds in just that process.
Yeah.
And then they're done. Their case in chief is done. What is the next thing that happens?
Well, you do what is called a trial order dismissal, and that's just based on the law, meaning that they didn't all the evidence they brought in doesn't amount, or they didn't meet the elements of each crime, like we talked about.
And is there a metric that the judge would make that decision?
Yes.
Do you recall it? Do you recall what it is?
In the lie most favorable to the people, I believe, is the first one.
Yes.
Lie most favorable to the people, and they judges usually don't throw the case unless it's like absolutely crap.
Yeah, usually judges
Yeah.
reserve their decision.
Yeah, I believe it's
Or they
lie
rule
most
on
favorable to the people. They reserve you.
Well, let's
Lies
sit there
more
for a
favorable
second.
to
So
the people.
basically,
They
yes.
look at the case based on,
When you say-
the prosecutors. The prosecutor side.
but-
They what?
I'm sorry.
Go ahead.
I want to phrase it in a way that's more understandable.
Okay.
You as a defense
Like
attorney,
how he likes.
huh?
No, go.
You as a defense attorney ask the judge, right?
To dismiss the case.
You dismiss this case
because they
and when you
haven't-
sit there and you ask the judge, say, Your Honor, you can look at everything the prosecutor says, and you can give them every favorable inference
Ruling, yeah, if-
you want to fucking give them, and their case is still fucking
Yes,
trash,
pretty much.
right? You know what I'm
Yeah,
saying?
yeah.
Even if you
Yeah.
give them every favorable inference,
Yeah.
everything that every gap that there is to leave, and you assume that what they said is true.
Yes.
They haven't
They
established
still
their
ain't got
case.
shit.
Because
Yeah.
it's an assault case and
Yes.
there's a lot of swinging, but there's no contact.
Exactly.
There's no
That's what it is.
testimony of contact.
It's shit. Even if you look at, if you give them the deference.
Exactly.
That's what the case is.
That's what you're saying.
That's the first one. Then the defense puts on a case if they want to.
They want to.
Which,
Why
But-
and then why are you doing it or not doing that?
I mean, I certainly prep my cases without my client testifying or without having a defense.
But,
You know,
okay, but
because
why-
it's their job. It's
Yes,
their job.
but,
They have
but if it, now it's I guess what I'm trying to say is we hit this point of the trial, right? Why are you putting on a case? I mean, let me just answer it, right? You're putting on a
Unless
case
it's a defense
because
that
you are concerned that at this point we're fucked. We lost the case, right? I mean, you don't know. Look, let me rephrase it differently, right? If you feel 100% after mid-trial, right, that you won the case, are you putting on a case? No.
I mean, I would never feel
Right?
100%. But what I'm saying is this.
Yeah, that's
I know
the
thing. That's
if
the
I
metric.
feel confident.
Yes.
Well, first of all, there's
It's confidence.
different ways and different reasons when you put a defense. If you have a self-defense case,
Self-defense.
you more
You
than
pretty
likely,
much
more than
gotta-
likely, I'm
yeah.
gonna say 94% of the time you have to put your client on.
Okay.
Legally, you don't have to, but you might. want
95
to.
exactly.
Yeah, the jury
So
wanna
there's
hear
different defenses that you need your client there.
Okay.
You know, like, and that's one of them, and that's why the defense will put on a case, or maybe there's witnesses to the
Right.
freaking crime, and you're like, oh, this homeboy fucking saw that the other guy swung first.
Right.
You put him on.
Like
You
each
know,
time-
oh, this guy was in the fucking car when my client is alleged to be driving drunk, but my client didn't have a fucking single drink. You know, he had a cough syrup or like whatever. You put him on. There's very, I'm gonna say it's rare. It's rare when the defense should put on a case.
Okay.
My opinion, the way I try cases, people might differ.
If you're badass at cross-examination, you really shouldn't have to put on a case. You know what I mean? Like, if their case is just trash anyway,
Depends on the
and
case.
you're cross-examining really good, you don't necessarily need to put on a
What
case.
are you gonna say?
Well, I was gonna say, like, usually when I meet a client for the first time, I'm trying my case right there, based on whatever you tell me. So it's like a checklist. You tell me this is what happened to you. I'm like, okay. So if it's a self-defense case, if it's a DWI case, if it's paperwork, if it's evidence, so right there and then I'm saying, okay, this is what I need for the trial.
And if you build everything you need for the trial in the beginning, and you get that from your client, as the case goes along, and when you get to trial, you have everything that you need for the trial. So now at the trial stage, when you're saying, do I put on a case? It's based on everything that's transpired at that time. So all the evidence I've gathered, my client's test, what he's told me, the witnesses, and now what the prosecutor has said. And then based on that, I'm like, I don't need to put on the case.
Yeah.
They didn't prove
That's if your client wants to talk to you. There's clients of clients.
Yeah.
Some clients don't want to fucking speak to you. Don't care about it.
And so, procedurally, the defense's case, if it's put on, will basically operate the same way the prosecution
Yes.
case, right? You'll put on new
Defense
witnesses,
does open-ended questions, which is the complete opposite. I said,
what you were doing to their witnesses.
Exactly. And the prosecution gets to cross-examine, close-ended questions. After all of that, then you do a second trial or dismissal. This is just for appeal purposes, right? So the appellate court can see and look to see if legally this case stands. If the prosecution proved every element of every crime, as we talked about before.
My only thing would be like, no, that's what should happen, but we now say it's for appeal purposes because but it's never usually granted.
And
You
what
are
is,
right.
does the language in terms of how the judge should be looking at
You are
it change from the mid-trial trial order dismissal as
Yes.
compared to that? What,
It's a
what changes?
reasonable view of the evidence.
Okay.
So now it's not just, the DA getting deference to everything, but it's just a reasonable, whatever the hell that means. Nobody fucking knows now, that's just the language that they look at.
Okay.
But it's not, it shouldn't be just giving them the deference out of everything. It should be
And
reasonable.
basically, just to, get to the point, is just that the concept behind that is that a judge shouldn't even give the case to be deliberated by the jury.
Yes.
If, as the judge, they're sitting there going, there's no fucking case.
Yes, they should
There's
dismiss
no
it.
reasonable
Yes.
person should ever think
Yes.
that this person committed
Yes.
this crime
Yeah.
based on what I judge, what I was like a third party neutral arbitrator of the situation can ascertain from it. Like
Yeah.
the jury shouldn't even be involved.
Yeah.
That's basically how that works.
Yeah.
But then going back to your example, as a judge, that's a
Yeah.
tough decision
That's
to make.
the most.
If I don't know if the kid did the bet on that, so I'm gonna let the jury decide.
Yeah.
I'm
Exactly.
not
The
deciding that.
jury is the judge of the facts.
Right.
That's what they say. The
And
judge is the judge of the law. So then after that, which you mean, we talked about summation, summation even yet, is the law. After the trial or dismissal is the law.
Right.
So
Yeah.
you can get the judge to, based on.
I think a good way to kind of like explain it further is that like the mom is sitting there going, the bet wasn't made, but then in fact you actually didn't hear testimony throughout the entire trial. This fucking kid even lives in that house.
Oh, yeah.
You know what I mean?
Well,
Like she basically sit there and goes, I walked upstairs, the bed wasn't made.
I mean, that should
But
be
not
thrown out in
one
the first
at one
trial.
point did she go, on Monday, on this date,
Yeah.
he slept in that bed. It's like maybe
But
someone else
that,
fucked
but,
that
but,
bed.
that, but that almost never gets granted.
Yeah, it
Yeah.
never- it never-
They
Alright.
reserve
So-
decision, as Jubril said. They reserve decision to see what the jury.
And so this, I think, like you said, summation, jury
legal-
selection
the
could
legal,
be one of those important elements of a trial. As whatever time we have left, let's discuss summation and how that differs from opening statements.
Always sentence. So well, before summation, you do the legal instructions which the judge gives, which are, they're all the instructions that you're going to touch on after in summation. Because
Okay.
if you have justification, which is self-defense, you can get that, the defense of yourself, when somebody attacks you, you can attack them back, or the defense of others. If somebody's attacking you, I can attack them to save him. That's what it is.
Good.
It's the defense of others. So that you discuss with the judge all these instructions, and you discuss them, and they're like, okay, they're going to be given to the jury. And then summation starts.
Just the idea is that there's like a conversation that involves the defense, right? The client's there, the prosecutor,
Yeah.
and the judge, in which you guys agree that there's going to be instructions that's
Yes.
going to be given to the jury that you will know ahead of time what they are,
Yes.
so you can tailor your summation to those instructions.
Yes, and you know what? And that's actually great because you do this outside the presence of the jury.
Yes.
Because there's some instructions that can actually be argued for and they're never given.
Yes.
So
why
you
is
do
that?
that
Because
outside
they can taint the jury.
because they can taint the jury. So you do that outside the presence of the jury, like you said, and then the summation you should know already what instructions are going to come in, what are not, and then you just tailor your summation, like you said, to the jury instructions. And your summation is you can refer to anything that was mentioned in the case. And you can be persuasive and you can be argumentative, which is one of the things that they don't allow. Meaning you can argue, okay, you saw this, so that is what, like that. You can argue in summation. In opening statement, you cannot argue. You can only tell them, okay, this is what the evidence will show. This is what the evidence will show. And DAs do that a lot. In summation, you just go, the evidence said this, thus that. That's, as defense attorneys, what we do. DAs also do that. The evidence showed this, so, I met this element, because of this and that, and that's how a summation is. You can refer to the trial itself, but that's not evidence.
I think the best analogy I ever heard of a summation is this concept, right? That you spend the whole trial developing the building blocks to whatever you want to build, right? Like you've developed the evidence, and only during the summation do you start to put it together and go, look at all these elements, all these building blocks. I'm going to build you a not guilty, or I'm going to build you a guilty, like a house. You know what I mean? And then it's like the person who builds the most clearest, I can see that picture so clearly based on the combination of all these things that was established in the trial.
I like that, but I don't like that because you're putting yourself, you're saying you have a job of building, and you don't have a job of building shit in this criminal justice system. You shouldn't.
You shouldn't,
Right.
but
You
you
shouldn't.
do.
You shouldn't.
I mean,
but we shouldn't conform to that.
Well-
we shouldn't conform to just because they're building and we
I
have
think-
to build and that's you fucking
You don't.
break that wall
this,
down.
This is what I would say, right? I
what you
think
do.
you're right. You don't, right? And I think.
But I know
I think
you
there's. I think this kind of goes to what we said in the beginning, which is that trials are a scary place to be at, whether you're innocent or not, because the scary, the terrifying thing that can happen at a trial is that everything can go your way, right? In terms of how you think this shit should shake out, and then you know what happens? You got a prosecutor who's make it nasty, fire prosecutor, persuasive, and he puts these pieces together, and they shouldn't add up to shit. And he's fucking the Van Gogh of fucking closing arguments, and he just makes it look beautiful. He makes it look natural, and then you have not necessarily a shitty defense attorney, but someone who just his message gets lost in the sauce, and he doesn't take these what should be a not guilty. He doesn't piece it together and leave the jury with a persuasive argument, and the jury believes the wrong thing more than they believe the right thing.
Yeah.
Right? I mean, that's what terrifies me
Well,
about the process.
it's because it's a totally calling, bro.
It's art. I mean, trials are art.
It is. You're right in a way. It is.
There's so many things we don't
I'm gonna tell you
control.
what it is.
We
Like
don't.
it's plain and simple words. Like a trial's like a story. Because when you start, you tell them what you're gonna tell them. You don't go in depth, but you tell them what you're gonna tell them. You tell them during the trial, and then in summation, you tell them what you told them. Boom. It's just like a paintbrush. That's what it is. But just can't lose track of trust that, and just the mindset that you don't have a job here. It's the DA, and it's very difficult, as you guys said, to get the jury to know and get in their mindset that that's the case. It's very difficult. Super, super difficult. And as defense attorneys, that's what we have to do. And as prosecutors, they have to build their case, and at the end of the day, you can only hope that the jury gets it right.
My only thing about trials is, right, like I obsess about my trials, right? If I have a client, I have a civil case or criminal case, I'm constantly thinking about it. And even as attorneys, we might bounce ideas off each other. I'm like, yo, how do you think a jury would perceive this or perceive that? And it's very frustrating because you try to think of everything. Then after you get a verdict, and you speak to a juror, and they're like,
Oh,
I was
that
waiting for
shit
you
you
to
thought
talk
was
ab-
important wasn't that important.
Yeah, it wasn't.
Or why didn't you talk about this? Or I wish you spoke about that. It's like we obsess about things so much as attorneys, trial attorneys.
That's
and
a fact.
we're trying to compensate for everything you're thinking about.
Yeah.
I was like, well, we were waiting for you to ask him this question. And just like we spoke about, we don't know what he's going to say. Or there might have been a ruling by the judge that you can't say that. You can't talk about anything about that. But that's something.
I think there's something very dangerous about trials, which is why I take a lot of discounts. Which is that it's perception's reality, right? In life and in trials. And the perception of what they saw, the jury, right? What they perceive to have happened is going to be the determiner of what happened for this person's life, your client, then what happened, right? Because you weren't there.
Yeah, they're not.
The jury wasn't there. So it's about what they think happened, not what actually happened. A trial is not the determiner of truth. It's the determiner of what a jury thinks is the truth.
Yeah. I mean, look, it's a gamble.
It's a gamble.
Roll the dice.
Roll the dice.
Go to trial.
Just heard some terrible news about Kobe Bryant, man. That was one of my idols. I'm a Laker fan, true, through and through. So, rest in peace.
We cheers.
To the Mamba.
I just want to cheer to the Black Mamba, baby.
To the Black Mamba, bro. That,
Love
yeah.
you, man. Yeah.
Cheers, guys.
Next time. Yo, the song's in the key of life. We reppin' the people's rights. No matter how dark it gets, the blues will come out at night. So call me a trick-or-treater. Always a calm demeanor. Whether you looking at life or just a misdemeanor. Whether you're smoking weed, whether you getting green, whether you caught up in some shit that you didn't mean, just believe us. We trying to teach you the rights to read you. It's just procedure. Trials, instruction, procedure. AWS gon' teach ya. Trials, instruction, procedure. AWS gon' teach ya.
Here's a tip, don't get it twisted. Stay focused on the message or you gon' miss it. When your case go to trial, it should be hitting different. The jury of your peers, do you really wanna risk it? Just because you're innocent don't mean you in the clear. When you try to tell your story, no